Morning, Ms. Reed. All right. So, Paul, can I see it? Thanks. All right. What I want to start with are motions that were either allowed by agreement. I just want to make sure our record's completely accurate. And if it's not, it's my error. So motions that I have that were allowed by agreement. I may need to take 1 minute. Jim, I'll be right back.
Board, all rise. Court's in recess and proceed.
I forgot something. Yeah.
Which one will you bet? Bill, Mike?
Yeah, but I just, yeah.
My dad?
All rise, please.
All right, thank you. So, allowed by agreement or previously allowed by me. The motion eliminate to admit the 911 call, was there an objection to that? It is paper number 298.
There was no objection.
Yeah, I have that as allowed by agreement, so, okay. The motion for the court reporter 291 and impoundment of what is supposed to be impounded, that was allowed by agreement as well, correct?
Yes, Your Honor.
And Commonwealth filed a motion regarding Zoom as opposed to webinar, and that was allowed by agreement as well, 292.
No objection.
And motion to allow in-court identification, paper 294, that was allowed by agreement as well.
No objection.
Okay. Motion eliminated to admit the victim's photograph. I have not seen which photograph you're using, but you're in agreement that about the photograph. Is that right?
Yes, yes. That won't be an issue.
I have it as allowed by agreement. Are you using one or more, or have you not decided yet?
Just one, Your Honor, and I provided counsel with a copy of that as well as some other things today.
Yeah,
Okay.
by agreement.
All right. Thank you. 295, Jim?
Thank you.
Commonwealth's motion eliminated to admit photographs of Mr. O'Keefe's injuries during the autopsy. We had a lot of discussion with jurors about this. This motion is allowed by agreement, correct?
Which number was that?
I'm sorry, that was 296. So Commonwealth's motion eliminated to admit the paper number 307. I believe this was allowed. Commonwealth's motion eliminated to admit defendants' out-of-court statements for purposes of medical treatment and certified medical records from the Good Samaritan Hospital. The notation that I had written on this was that the defendant has no objection to the admission of statements made for the purpose of medical treatment and medical records. The court takes under advisement testimony regarding the blood alcohol testing because that's a separate issue, and we'll address that today. Is that your understanding of where we stand with this motion?
Yes, that's our understanding.
Yes, Your Honor.
Okay. Jim, that was, I already said that, right? 307.
Yes, thank you.
The use of leading questions on John O'Keefe's young niece and nephew, we'll see where we stand. I think I said to Mr. Lally, jurors would rather hear from the witness than the lawyer. So let's see how it goes. And if you think that you need to switch to leading questions, please just come to sidebar. I'll give you the leeway you need, of course, based on the child's testimony or child's manner of testifying. All right, so you were both in an agreement on what I have as 316 and the defendant's motion number paper 288 regarding any reference to Aiden Kearney, aka Turtle Boy, or his pending criminal charges for witness intimidation. So both parties have agreed to not introduce this in evidence in their case in chief. If anyone opens the door, the motion will be revisited, and I think I said that I sort of disagreed with you both. I do think if witnesses testify to this spontaneously, then it comes in, and it can be pursued further, but just come to sidebar. All right, 312, Commonwealth's motion to preclude reference to any bad character or any prior misconduct of the victim or any witness. That was allowed by agreement. Mr. Yannetti?
Do you know which motion we're talking about? Oh, yes. Oh, no, that's agreed.
That was 312, Jim.
Thank you.
313, motion eliminate to exclude character, reputation evidence of the defendant. You're not putting in reputation evidence, right? We talked about this, Mr. Yannetti?
This is a motion to exclude good character evidence. Is that
It's paper number,
by the Commonwealth?
it was filed by the defendant, and I questioned whether you intended to put in character evidence, and you told me no.
That is accurate.
Okay, so that's allowed too, Jim.
Which one was that?
313, let me just check.
That's a Commonwealth one.
It is. Commonwealth's motion. It's 313, other Commonwealth date stamped, I guess, or date stamped 23.
Thank you.
There was no objection to the Commonwealth's motion in limine to introduce certified records from the registry, correct, Mr.
Correct.
Yannetti? Okay.
Correct.
All right, and then motions that perhaps were not agreed upon, but I previously ruled on. So, or I think I ruled on them. If not, these are my rulings. 297, Commonwealth's number 7. Commonwealth's motion eliminate to preclude reference and redact the manner of death contained on the victim's death certificate. And I think I said in open court, this motion is denied as to cross-examination of the medical expert, but that undetermined language will not appear. That will be redacted from the death certificate. You'll have the live witness here to cross-examine as to that. So, Jim, that's 297.
Yes, Your Honor.
Commonwealth's motion eliminate to prohibit reference to any federal investigations, paper 317, Commonwealth bold stamp 27, to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office and or Federal Bureau of Investigations. That motion was allowed after hearing. 305 is the motion regarding chalks. We'll address that when we address the defendant's motion regarding their audiovisual person. The third-party culprit, the ruling's clear on that, not in opening. That's 320-30. I think that was clear when we talked about it. All right, so those are the ones that were fairly quick to just go through. I've got another set that are sort of in the fairly quick range. And then we'll move on to the Commonwealth's discovery type motions. So first, paper 284, defendant's motion for sanctions and exclusion of evidence based on the Commonwealth's failure to timely comply with discovery orders. Mr. Jackson, you told us at sidebar the other day that you are withdrawing that motion, correct?
Correct, Your Honor.
All right, so Mr. Clerk, that's motion 285, paper 285, withdrawn by counsel.
I'm sorry, Judge, 284?
Okay, I have it as 285, but
285 is the affidavit.
okay, yep. So 283,
Thank you.
withdrawn by counsel. Motion eliminate for review. So, as defense counsel plainly states that a defendant is not entitled to be present at a view. And what I've determined here is that based on concerns for security issues and frankly distracting the jurors, the defendant will not be present with us on the view. And as you've stated here, that is well within my discretion. All right, Commonwealth's motion eliminate to admit defendants out-of-court statements as statements of a party opponent. So I think that this was one of the ones that you all agreed to. Paper 308, 18 on the top, and it's followed by paper 19 regarding the various statements made to the media, to Boston Magazine, to ABC News correspondents. So I think the defendant had said previously that you were in agreement that all these statements come in. Is that right, Mr. Yannetti?
Sorry, Your Honor. Yes, that's correct.
All right. So I had a logistical question about, I don't know how long the ABC News interview is. How long is that?
Your Honor, what I can say is as to each of those, the Commonwealth's intention would be to play, to omit the entirety of the interviews, but to only play selected portions of those interviews.
All right, because what I did, I re-listened to the nearly 4 hours, 3 hours and 40 minutes of the Boston Magazine audio, and there's no objection to it from counsel. What I listened to, it made sense, and I didn't know how you would play a 3 hour and 40 minute audio. If you think you need to, we just need time to be able to put it into the schedule.
Sure.
Okay?
But no, I don't feel the need to play the entirety of it.
Okay. I was involved in a trial once where we watched a whole movie. So just give me a heads up if you think it's a lengthy segment. But how long is the ABC interview, just in case counsel wants to go back and fill in?
I think the portions that we have are not terribly lengthy. And as far as the statements are concerned, it's even less so of that.
All right. So does defense counsel intend to also play I'm trying to find out if we're going to need a whole 3 hour and 40 minutes. I need to know that. I still haven't got an answer as to how long the Dateline or ABC, whatever it was, video and audio is. How long is the entire thing? Do you know?
You're asking me?
Either of you. I don't have that, so I didn't review it.
May I have just a moment with
Yes.
counsel?
You're right. My memory and my belief is I think, and I can't recall specifically which one is one or the other, but I think one is about 10 minutes long, the other is about 5 minutes long, and again, I would only be playing, if any, portions of, the defendant's statements, not the entirety of the broadcast.
Okay.
And if there are portions that weren't played, I would expect.
So that's what I'm trying to figure out. So I'm concerned on the 3 hour and 40 minute one, which seems to be all of it's admissible. There's no objection to it. And if, I just need to know if we're going to play something for 3 hours and 40 minutes. The other one, if it's 15 minutes, I don't need as much heads up.
My guess would be anything that we would want to present that wasn't presented would be in the 15, 20-minute
Okay,
category.
that's
not
fine.
3 hours.
It's just for scheduling purposes. Right. All right. So, Jim,
Yes.
paper 309 and 308, they're the same pretty much. Those are allowed by agreement.
Okay.
All right. And it's sort of in the same vein. So it's another statement of the defendant. It's the statement of the defendant at the Milton State Police Barracks that I had not seen before because it was post grand jury, and we watched it. I had the opportunity to watch what we all watched here in court last Friday, And over the weekend, I watched the entire hour and a half or so of it. So you're in agreement that the statement comes in, and the Commonwealth says that the Commonwealth needs some leeway to show that she was in custody after arrest for a period of time, and Commonwealth wants to play the video. I don't think we need the video. Much of it is just looking at their computer. So the video part will be out. You don't want it in, correct?
That's correct. We had
Yes.
asked for the audio only.
Yeah. Okay. So the audio only, but it needs some context. It's not just that she's sitting down having a cup of coffee with the police and makes these statements. So they're clearly voluntary, clearly unsolicited. How do you want to work that out? Can it be that this occurred at the Milton State Police Barracks on a particular date? Because if you can't work it out, then I'll decide it.
That makes sense.
303?
Yeah, I mean, from our position, Your Honor, we don't object that the statements were made at the Milton State Police Barracks as they were, and it was in that context that she was speaking to the police at the barracks. We would object to introducing evidence that she was under arrest at that time.
Yeah, I don't think we need that. But so at the Milton State Police Barracks on a particular date.
That's acceptable.
Do you need more than that, Mr. Lally, for context?
No, Your Honor.
Okay. How is this going in?
Through the trooper to whom she was speaking.
Okay. All right. All right. So, Mr. Clerk, audio only. Commonwealth may elicit testimony. Statement occurred at the Milton State Police Barracks. Mr. Lally, do you remember the date?
June 9th, 2022.
Thank you.
22?
Yes.
Okay. So audio only, Mr. Clerk. Commonwealth may elicit testimony that the statement occurred at the Massachusetts State Police Barracks on June 9th, 2022. All right, so those are the fairly quick ones. Before we get to what I think are the more complex ones, or the ones that I need a little bit more argument from you on, I am concerned about discovery. So, Mr. Lally, when I was going through copies of what I had previously, the first time or one time that Commonwealth filed on March 21st of this year a notice for reciprocal discovery and notice of experts. You then, last week, I think, filed a renewed motion for reciprocal discovery and request for voir dire of any defense experts. You asked that that be impounded. And that will be based on your motion and appears to be sort of an affidavit in support. So where do we stand with discovery?
So, with reference to the reciprocal discovery, what Commonwealth is seeking is noted there are a number of witnesses listed on the defendant's witness list with no materials provided as to who these people are or what their intended testimony is. The issue with regard to experts is essentially there are 5 experts. Mr. Green, who there was an attachment to a motion with an affidavit and some materials. I think I have everything in relation to that. With regard to Dr. Sheridan, I have an affidavit and a curriculum vitae, and that's essentially it with respect to that. I just am inquiring as to whether or not there are any reports or any other sort of findings or anything post that. The other 3 experts all relate to that specific, I'm sorry. The next would be Dr. Van E., who,
Which, I'm sorry, I didn't hear you.
Dr. Christopher Van E.
Yeah.
I'm a little, so essentially that gentleman and then 3 individuals from this ARCA company who are all purported to be testifying in the area of crash reconstruction. None of them are crash reconstructionists. They're all biomechanical or biomedical engineers. With regard to Dr. Van E., who I've had some experience with in the past, my typical dealings with him is there's some sort of report written by him. I have nothing. I just have a CV and about a paragraph of what's anticipated as far as his testimony. The other 3 individuals, my issue is there is a report that's within the federal materials in relation to what they did. However, it's a single
In relation to
report.
what?
In regard to whatever examinations or tests or whatever that.
Does it include all 3 experts, though?
Well, so that's the issue.
Yeah.
The issue is the report is signed by all 3 individuals. So I have no idea who did what, who would testify to what, who has an opinion as to what, or what that would be. So I'm just looking for some additional information or any clarification as to what each of those respective people would be testifying to beyond just all 3 signed a report.
Okay, who's arguing this for the defense?
With the court's permission, I'd like to handle the issue regarding civilian witnesses and have Mr. Jackson address the experts.
All right.
So my argument's very brief, Your Honor. We're well aware of our obligations under Rule 14, and any statements that we have regarding civilian witnesses that fall under that rubric, we will turn over, and we have turned over.
But why haven't you?
No, we've turned over what we have. So in our view, we've complied with discovery with regard to the civilian witnesses that Mr. Lally speaks about.
All right. Do you have addresses for those witnesses, Mr. Lally?
We did it. Yeah.
All right. So they need addresses, right? If there's nothing there, they need the addresses so the police can go out and interview them.
We will get them addresses by the end of the day today.
Okay. All right. So my concern was that when, Mr. Lally, when did you file your certificate of compliance?
That would have been, I believe the Wednesday, not last Wednesday, the Wednesday before that.
And I had previously told counsel I would expect within 2 days of that because obviously you've been preparing this case for a long time.
Of course, yes.
But so to have Mr. Lally stand here today and say that he doesn't have all this information that you know he's entitled to, I mean, dates of birth and addresses of witnesses are pretty standard, Ms. Giannetti, especially if you have, not provided anything that they're going to say. So that should have happened a week ago.
Your Honor,
If I may defer to my co-counsel.
Well, okay. And we do have to talk about how we're going to do this at trial. Okay.
Yes.
Your Honor, I provided reciprocal discovery to Mr. Lally within 24 hours of receiving
Okay.
the certificate of compliance.
Anything about these witnesses that Ms. Giannetti says they have everything on?
Yes, he's received statements from all the witnesses that we have statements for, which included their dates of birth, addresses.
How many is that, Ms. Little? How many witnesses?
I don't know off the top of my head, but every single report that we have for these witnesses that Mr. Lally has received in his witness list, he has reports for.
Okay.
And a number of our witnesses, obviously, are witnesses that the Commonwealth has interviewed.
Right. I think I crossed out much of your list when I read the names of the witnesses, right?
Exactly.
Because they were duplicates.
So we have complied with at least those obligations. And if there's any addresses that we haven't produced, I will make sure that gets done today, but he
Thank
should
you.
have the vast majority of everything.
All right. Anything specific, Mr. Lally, on the civilian witnesses?
Well, just in looking at the defense witness list, there are 77 witnesses that are listed. 35 of them are on the Commonwealth's witness list, and I have statements from 4 witnesses, not including experts, so that would probably make it to 9, or if you include the investigator, 10 or 11. So there's still a substantial amount of witnesses that I don't have addresses, date of births, or any statements from, or even what their anticipated testimony would be.
Your Honor, there's also probably an additional 10 to 12 witnesses that he has reports for from the federal materials, which include addresses, statements, that type of information.
All right. It's my view that that's still the defendant's obligation to provide. All right, or at least acknowledge where they are. All right, let me hear the expert response, Mr. Jackson.
Your Honor, with regard to Dr. Vanny, Chris Vanny, first of all, he is technically a rebuttal witness. There's a trooper named Trooper Paul that's going to be called in the Commonwealth's case in chief, and he's going to testify to some key cycle information. Key cycles are trigger events or cycling events with regard to the SUV. Chris Vanny is expected to testify in rebuttal to Trooper Paul's testimony that his Trooper Paul's analysis of the key cycles is flawed in terms of timing and the number of key cycles that he relates back to an event that takes the SUV back to 34 Fairview. So Chris Vanny has done a similar analysis, or at least overviewed or looked over Trooper Paul's analysis and has determined that Trooper Paul's analysis is incorrect. So
All right.
we included his name, although he's a rebuttal witness, we included his name just to be in an abundance of caution.
All
He
right.
has not produced a report.
Do you have to at least tell the Commonwealth what he bases his opinion on, what he has viewed, what he bases his opinion on?
The exact same information, the raw data that Trooper Paul based his opinion on.
All right, so is this the first you're hearing this, Mr. Lally?
There's kind of a vague description to that effect, but again, what I'm hearing is similar to that in the sense of he disagrees with the Commonwealth's expert, but I don't have any foundation for that or what specifically he disagrees about or what his points of contention would be with Trooper Paul's report as far as no report, no basis of opinion, no anything of that nature. That's my concern.
Okay. And you've requested a voir dire
Yes, Your
of
Honor.
the experts? All right. We don't want to bring this witness out here early for a voir dire, so I suggest you get the information that was requested.
I'll be happy to.
If we have to bring him out, we have to bring him out.
No, I'm not looking to bring him out, and I don't think that he needs to be voir dired. He's going to look at the exact same, and I'll call Mr. Lally and explain to him what I think in a little bit more granular detail is going to be the sum and substance of his testimony, but Mr. Lally he certainly can conceive, as Trooper Paul walks through his analysis, Chris Vanny is going to walk through the exact same analysis. It's the same data set. They're both working with apples and apples. He just has a different conclusion that the key cycles are not in keeping with what Trooper Paul analyzed because he left some key cycles out. Pretty simple stuff. But I'm happy to contact Mr. Lally offline and let him know exactly what it is that
All
Chris
right.
Vanny has a
All
problem
right. So you do that, and if it's not resolved by Monday, we will pick a date within the next week to have voir dires of whatever experts that insufficient discovery has been provided to the Commonwealth on. So let's try and work everything out. The rules are very clear, and you need to provide this information.
And I thought we had, but I'm happy to have that additional conversation. And I'll do the same thing with regard to the ARCA witnesses as well.
So is there anything specifically, Mr. Lally, that you're looking for today in response to the biomechanical engineers?
Just specifically what their opinions are and what they're based on.
And who did what?
Who did what?
Should be fairly easy to provide, Mr. Jackson.
It has been in about a 9 or 10-page report. It's detailed, single-spaced.
But does it say who did what? I read the report as part of the federal materials. I couldn't figure out who did what. So,
Okay, I'm happy to talk to Mr. Lally about that. I believe the answer is going to be, in sum and substance, all of them work together as a team to come to the opinions and conclusions that are recited in the report. But I'll be happy to have an additional conversation with Mr. Lally about that. I don't know that I know every single thing. As a matter of fact, I don't know every single thing that everybody did, who screwed what bolt into what nut, et cetera. But I think, by and large, Mr. Lally and I can come to an agreement about what the contours of each of their testimony would be.
okay.
And by the way, they are accident reconstructionists, so there's a
Do you have their CVs?
I do, and so does Mr. Lally.
I do.
Anything on the CV about being accident reconstructionist?
There is listings of accident reconstructionists, but I think that's part of the Commonwealth's request for a voir dire is the qualifications. I don't think meet that standard for them to be able to testify in that area.
All right, so two things. When the two of you were working on this between now and Monday, if the Commonwealth is not satisfied in requesting a voir dire, I need to hear from the two of you whether we need to do that before the evidence really gets started, or if it can be done before the witness testifies.
Okay.
All right?
Understood, Your Honor.
All right, so Commonwealth's motion for voir dire of any witness to be asked for opinion or character of defendant or any witness. I had that this was allowed by agreement, 314, Diaz number 24.
That's agreed.
And 304, Commonwealth's bolded number 14, Commonwealth's motion for order regarding opening statements and notice of any visual aids defense intends to display to jury during opening statement. So I need to know what parties intend to put up for exhibits or for chalks, whatever you intend to put up in opening. And I know you're doing the opening, Ms. Giannetti, so I need to know what you intend to display.
Nothing.
Okay, that makes it easier. So while we're talking just briefly of openings, you had told me, Ms. Giannetti, that you thought you could get everything in 35 minutes. I will give you both 45 minutes.
Oh, that's perfect. Yes, I'll be less than 45.
I'll hold you to that.
I know you will.
All right, so Mr. Lally, 45 minutes for the Commonwealth?
Yes, Your Honor.
Okay. All right. And Commonwealth, do you intend to put anything up during openings?
During openings, no, Your Honor.
All right. Okay. Commonwealth's motion eliminate for notice and voir dire of Bowden. I thought that was, we decided that there would be a voir dire regarding before the Bowden testimony comes in.
I don't recall that, Your Honor.
All right. Well, Commonwealth's entitled to a voir dire. There'll be a voir dire.
My understanding of the court's ruling, as it applies to opening statements, is that I cannot point the finger at a third-party culprit, but I can introduce the idea of an inadequate investigation and discuss Bowden evidence.
As long as you know it's coming into evidence.
That's perfectly fair.
Remember, I use that term, competent evidence.
Of course.
That's what it has to be.
Of course.
All right. I'm sorry, Jim. 321, the Commonwealth's bolded 31, in case my number's not right.
Thank you.
319. So this is, we talked a little bit about this. It's Commonwealth's motion for advance notice if defendant intends to cross-examine any witness about alleged bias and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. So as you well know, Mr. Lally, bias is definitely an area that is ripe for cross-examination and extensive cross-examination. I needed to know exactly what your concerns are.
And, Your Honor, I think what I would suggest might make the most sense with this is to sort of take it as it comes.
Okay.
I think it's a little difficult to put counsel in a position to, cite specific things that they wish and
We have a couple of motions where we do need to do that.
Right.
But for generally with this, and because this was broad, that's why I did want to, when we had a brief hearing on this, I said that I did need to hear from you regarding specific statements. So what we're going to endorse this, Mr. Clerk, is that Commonwealth will object on a question-by-question basis. Does that work, Mr. Lally?
Yes, Your Honor.
Does that work for the defense, Mr. Yannetti?
For sure.
Okay.
Commonwealth will object.
Commonwealth will object to specific questions.
Thank you.
And Mr. Lally, if you know in advance, depending on how the testimony comes in, if a particular witness gets up and you know before any examination what your concerns are, we'll visit it before the testimony.
Understood.
Okay?
Thank you, Your Honor.
A similar motion to the defense expert issue. Mr. Clerk, I believe it's 315. It's bolded number 25 from the Commonwealth. Commonwealth's motion eliminate to prohibit defense experts from testifying regarding scientific studies or anecdotal experienced and request for voir dire. Mr. Jackson, do any of your witnesses intend to give anecdotal experiences?
I said this in the argument. I don't really know what that means, but no, in terms just the common sense knowledge of common sense definition of what that is. To my knowledge, they're not going to be talking about any.
Okay, I think it's pretty clear what it is. But if you think they're not going to do it, if it seems that they are, then we need to know. And how about the scientific studies?
The scientific studies would not be referred to in any of their testimony that I'm going to elicit at all.
Okay.
They did some scientific studying of the material.
No,
obviously.
do you mean like learned treatises and things like that, Mr. Lally?
Exactly, Your Honor.
Yes.
They're not going to be citing to learned treatises that I'm going to elicit.
Okay. All right. That's it in my category of discovery. There's some overlap in the motions that I think the following motions may take a little bit more time, and it's sort of the somewhat complex ones. So 311, Commonwealth's bold number 21. Commonwealth's motion eliminate to admit the victim's out-of-court statements relating to his state of mind. There's sort of some overlap, Mr. Lally, that we'll get into with other statements. But so this is the Commonwealth versus Qualls, Commonwealth versus Binns, that whole line of cases. Why don't I hear you? Is there any objection to this?
We may have a moment, Judge.
The Commonwealth, we were here last, the Commonwealth was told that they need to provide with the statements or the areas they intend to introduce. They do so in this motion. They do more extensively in another motion that's sort of dovetails. And the other motion concerns the Aruba incident, the arguments between the defendant and Mr. O'Keefe, and also this Binns/Qualls type testimony.
Right, so I think our position, Your Honor, was that we need to know the specifics of what they intend to introduce. My expectation is that some of that will be admissible and some of it we won't have an objection to, but it's difficult to give either a blanket objection or a blanket assent without knowing the specifics.
Okay, but you did sort of make a blanket objection to the Aruba incident, if we call it that.
We had to without knowing the specifics.
So on the second page of this motion, the Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. The Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship. That goes squarely with Qualls and Binns.
Right. With regard to the text messages, I don't believe we have a basis to object.
All right. So I'm also going to allow statement. Mr. Lally, tell us what the statements specifically, as best you can. Who would be testifying? What family members? Does this involve the two children?
Yes, Your Honor. So there are statements that are made by the victim to the defendant in front of each of the two children with his intention to.
What are they roughly?
Essentially that the relationship isn't working anymore and that he would like to break up with her, ask her to leave the house. She refuses, and this is in front of both the niece and the nephew.
All right. Ms. Giannetti, I'll hear you on that.
Our expectation is any statements that were made, allegedly made by Mr. O'Keefe to my client in front of other witnesses, we don't have a basis to object to that.
Okay, so that's coming in. And you've had the benefit of the SANE interviews for a long time.
Correct.
Right, so.
We don't waive potential hearsay objections during trial, Your Honor, but I think generally that's our answer.
All right, so on 311, Mr. Clerk, I'm going to allow that.
Yes, Your Honor.
Okay. All right, so sort of the same. 310. And the defendant's is 283. It's a similar motion. So, Mr. Lally, why don't I hear you on this? So this is the one when I said there are 3 areas here as I see it. If we call it the Aruba incident, the animosity between the defendant and the victim in weeks and days prior to the victim's death, and that the defendant admitted to numerous witnesses at different times that the last thing she recalls was getting into an argument with the victim. So that whole domestic violence line of cases with state of mind clearly is admissible. So why don't I start with you, Mr. Lally? Go ahead and argue your motion.
So, Your Honor, specifically, what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really 4 witnesses who have information to provide to the jury.
Do we need all 4?
Well, so from different perspectives is what I would say. So 2 of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately a 20-minute screaming match or something to that effect.
Both children were present?
Yes, within the hotel room, and both indicate to that. Then you have the woman, Marietta Sullivan, who's involved in the incident in the lobby, and then you have her sister, who is the person who invited them on the trip in the first place.
There's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that.
Okay.
What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship, or the nature of his relationship with the defendant.
And those statements have been provided to the defendant?
Yes, Your Honor.
There was testimony in the grand jury regarding those statements?
There is, yes. There's state police reports as well as testimony from the witness and the grand jury.
Okay.
In addition to that, as far as statements relative to the nature of the relationship, there are some minimal statements that are made by the defendant to a couple of witnesses at the waterfall the night before. Again, those are also contained within troopers' reports and the grand jury testimony of those witnesses. There are also the text messages between the victim, Mr. O'Keefe, and the defendant, which specifically address the nature of their relationship. There are text messages from the defendant to Mr. Higgins, which again specifically address not only the Aruba incidents weeks later, as well as and being a continuing point of concern, at least from the defendant's perspective, as to the nature of their relationship. And then taking all of that sort of in conjunction with the text messages between the two that day and the voicemails messages that the defendant left on the victim's cell phone shortly after the murder occurs. And then there are further statements that the defendant makes to a number of different people, whether they be troopers, whether it be paramedics, whether they be Ms. McCabe and Ms. Roberts, or in the presence of them, as well as at least 3 paramedics, indicating that the last time that she saw the victim, Mr. O'Keefe, they had gotten into an argument essentially at the house at Fairview Road right before she had left. So those are sort of the totality of the sort of specific areas in the nature of the relationship that the Commonwealth will be seeking to explore through the testimony of a number of different witnesses.
Okay. Who's arguing this for the defense?
I will, Judge. As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, it's difficult to, again, just give one blanket objection or one blanket assent to this. Generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the Qualls and the
Correct.
Binns line of cases. So
Correct.
I did rule that those are coming in.
We recognize that,
Okay.
yes.
You said probably.
Well, yes. Well,
Right.
Mr. Lally raised it again, so.
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what
okay.
it's, what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on
Okay.
not.
So that's well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah, so you haven't tried before me before. I would not do that. So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find pursuant to Commonwealth versus Samir. It's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth. So I will give a limiting instruction. I will welcome propose limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the Qualls and Binns line of cases. And I will give a limiting instruction. I'm confident the jurors will understand. So that's my ruling on that, which actually, so it would be a denial, Jim, of defendant's motion 283.
Just for the record, it's 282.
82. And that's denied. I mean, it will not go to propensity, and we can make sure of that. And the Commonwealth's motion is 310, Jim, the bold 20, and that was sort of hand in hand with the other one. All right. So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion to eliminate to admit expert celebrate demonstration. I think we briefly talked about it, and I wanted to know, so are the defendants objecting to the, so your witness's name again? I read it every day for the last week.
That's okay. It's Mr. Ian Whiffen.
Yes. So about him doing a demonstration, is there an objection to that from the defense?
Your Honor, since the last time we were in court, we've had an opportunity to look at that
Yeah, I'd like to look at it, but okay, so you looked at it?
We
Do you
did.
have-
We did. It's not that long. It's maybe, I don't know, I want to say 22, 25 minutes, something like that. We'll submit on the papers and stand on the objection that we previously made, that it doesn't comport with the exactitude that we think is necessary for a demonstration, but I don't think it bears. It's not an enormous deal for us. We do stand on the objection, but I'll submit on the papers.
All right, so I'm going to allow it, but Mr. Lally, I'd also like to see it.
Of course.
Okay, so if you could get me a copy, Ms. Gilman, can you get me a copy of that before the end of today?
I think so. Yes.
All right,
Not
thank
speaking
you.
for.
All right, so Jim, 306 is allowed?
Thank you.
All right, so the two that may take, there's three actually, but the two that we'll cover here before we get to sort of logistics and sequestration. Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive. I would submit as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a
But
witness.
why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lank being involved in some sort of altercation himself, in whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lake knows or was 20 some odd years ago friendly with one member of the Albert family or even two, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment. Particularly where it's an unsustained finding and there's nothing, concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in.
Right.
So who's arguing this part? We'll take these in two parts. So we'll do the Trooper Proctor part afterwards. But Ms. Little, I did say I'd give you the opportunity to argue those two cases, but if you want to, you can, but I'm more focused on the bias or motive
I'll
part.
just briefly address Graham and McFarland because
Sure.
I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously
But just let's focus on Lank first.
sure.
Okay.
So-
I agree with you. They're discovery cases. They're not admissibility
Okay.
cases.
So that issue aside, Lank has he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court's
The
attention.
Albert family appears to be
And I'm
huge, right?
Well,
or very extended family.
Well, I'm getting there. So
Okay.
the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is
Who would you intend to get, if I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lopolito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through, and how?
through Sergeant Lank himself. I think we
Okay.
need to be afforded the ability to cross-examine him. Once that's done, we may need the local
If he
law
denies
to-
it, and we'll
Exactly.
figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
So you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have, his testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our
Mr. Lally said,
cross-examination.
okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So, all right. So go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So, Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So
No, Your Honor.
let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So, I'm not going to take any action on this right now,
Okay.
but I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your
So
Honor.
we'll see where we go with this, okay? All right, so now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to NEI investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office, conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay?
in
How
relation to that.
recently? I mean, it's all recent. When was that?
That was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination, and particularly when it's an open investigation, there are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about, them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion, is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more, because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do, and just for that specific, because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing, and to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely there's no evidence to substantiate other than the fact that it exists, without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is, or that it even pertains to this case. So with regard to all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth. It's unfair to the witness to be put in that position when there's really no information available.
All right. What do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in
is-
the, hold on, is it something in the information that you've received
Yes, Your Honor.
from
and-
Mr. Lally?
Yes, Your Honor.
All right. So can I get a copy of that?
Yes, Your Honor.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So, regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no
I
basis for
didn't
that.
think you did.
But what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IAD, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel is talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was completely separate investigation initiated by the District Attorney's Office. in
Okay.
relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination.
What if they don't call Trooper Proctor?
We will call Trooper Proctor.
To impeach him?
Yes.
All right, so be prepared to argue that. I don't know. He's on the witness list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective
hypothetically
in this
throwing it out
case.
there.
He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others?
Sometimes, but he is the primary investigator in this case. And I think it's very, very important for the court, and I think you noted correctly, that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend to try and open on this, Ms. Giannetti? Because I need more information.
I'm not going to mention the IA investigation in my opening statement.
All right, so Mr. Lally, if you can get me that information that you mentioned that you had sent to counsel, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation, and if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So, all right, so we need a little time. I need to read those materials.
Sure. And for the court's edification, I don't anticipate he's sort of towards the middle, I would say.
Okay. All right, good. And the more fully the record's developed, and the easier to rule on some of these motions. I just want to give you all some idea so you know how to prepare for the next 2 weeks. So, all right. So not in your openings on either one of these, Ms. Giannetti, but you agree to that. So this is still under advisement. It may be certainly with Lank or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert. We'll see how the evidence develops, and I'll read more about the information that the Commonwealth has provided. So 318 also. It's 28 bolded from the Commonwealth. All right, so Commonwealth's motion eliminate to admit, this is, you know what, I don't have a number on this one, Jim. Commonwealth's motion eliminate to admit results of defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation.
Judge, that's paper 339.
All right, and the Commonwealth, the defendant's is 289. It's the addressing the same issues. Yeah, I told the Commonwealth to put this in writing. So I guess it's defendant's motion. So I'll hear from the defense. Your motion 289.
Thank you, Your Honor. With regard to that, we've put most of our argument in the paper, so I don't want to rehash all of those. The issue is really the foundational issue, not the extrapolation. The extrapolation is sort of a garbage in, garbage out argument, like computers. We think that the underlying blood draw did not follow the proper protocols that it should have followed. Therefore, the veracity of that particular blood draw is at issue.
All right, can I just ask, the Commonwealth intends to have witnesses here to testify to that, right? How the
Yes.
blood was drawn, all of that?
Commonwealth would have the doctor that ordered the blood draw, the nurse / nurse practitioner. I summons both as far as who took the blood, and then the director of the lab at the Good Samaritan Medical Center. What I hope to...
So let me get back to Mr. Jackson, and then I'll hear you on that. I just wanted that. I'm not sure we had all that information when you filed the motion, but does that change anything, Mr. Jackson?
It doesn't, because the individuals that did the blood draw It wasn't done in an accredited manner. I'm not arguing with the fact that the blood draw was taken, that somebody with a phlebotomist actually took the blood, but it wasn't done with the protocols or the accreditation that's required under Massachusetts state law and the Massachusetts State Police Crime Lab. Their protocols were, I apologize, their protocols were breached internally, and given that breach, we believe that any extrapolation based or founded upon those faulty blood draws, those unaccredited blood draws, are suspect as well. So the sum and substance is that you can't trust the extrapolation if it wasn't an accredited and a foundationally solid blood draw to begin with.
So if all the witnesses are here for cross-examination, why doesn't that go to the weight of the evidence instead of the admissibility?
Because we think that the admissibility is based on the protocols that the Massachusetts State Police have put in place. If they didn't have accreditation protocols, it wouldn't mean anything. It probably would go to the weight, not the admissibility. I think the admissibility is predicated on their own rules. They don't get, in our view, they don't get to break their own rules and then say, oh, well, let's just let it go to the weight, not the admissibility. We believe that it's important enough that it shouldn't ever come in front of the jury in the first place, notwithstanding the fact that we could obviously cross-examine them on the lack of accreditation. We think that it rises to the next level of not being trustworthy, and therefore it's overly prejudicial.
Okay. Mr. Lally, doesn't this happen in hospitals across Massachusetts on a regular basis?
It does, and just to be clear, nobody's breaking anybody's own rules. This wasn't blood work that was taken by anybody at the lab or tested at the lab. It was taken at the hospital, tested at the hospital, and what the technician or the forensic scientist from the Office of Alcohol Testing is doing is essentially mathematical calculations based on that result. So I would submit it goes exactly to the weight of the evidence. It's certainly fertile ground for cross-examination or argument by counsel. But as far as it being admissible, it's certainly admissible. This is what happens in every case. Whether or not Good Samaritan Medical Center's lab is ANAB accredited or anything of that nature is irrelevant. It has nothing to do with the state police strictures because they're not the ones who actually conducted the testing of what was in the blood.
All right, do you want to respond?
I just wanted to refresh the court's recollection. I mentioned this at the last hearing, but just one element of the problem is in the result. The extrapolated result was 124% swing. In other words, we extrapolated based on the blood draw.
Yeah, I know what it means.
And that's just massive. I've never seen a swing that big. It's, you pull somebody over. Well, they have
Sounds like a great area for cross-examination.
I think it will be.
Okay.
But if it's not admissible in the first place because it's inherently untrustworthy, then you could save me my breath.
Yeah. I don't see how this doesn't come in.
I'll submit, I don't want to beat a dead horse. I just think that it's so unreliable that it shouldn't be put before the jury. And we run the risk of prejudicing the jury in a way that we can't sort of unring that bell. Yes, we can cross-examine, but I don't think that the underlying blood draw is foundationally solid enough.
Mr. Lally, were you planning on using this in your opening?
I don't have to.
All right, so why don't we wait and, if need be, we'll have the experts. Let's wait until it gets closer to these experts or the folks from the hospital testifying. If we need to have a short voir dire, you need to remind me to do that, Mr. Jackson, okay?
Thank you for that, Your Honor. I appreciate it.
All right. Okay, so the last area I have is sort of logistics and sequestration. So the Commonwealth filed a motion initially. You know what? We'll hold off on the logistics regarding the audiovisual assistant. So there was a motion in limine for sequestration that I allowed regarding the family. So the victim's brother, Paul O'Keefe, the sister-in-law, Erin O'Keefe, the niece and nephew, can attend the trial after their testimony. So that motion 293 is allowed. I understand that perhaps, I was going to also allow Mr. O'Keefe's father, who appears for some reason on the defendant's witness list. He is exempt also by me from the sequestration order. All right, so that's John O'Keefe Sr. So I just added that in. So, Mr. Clerk, 293 is allowed with the addition of Mr. O'Keefe
Thank you.
Sr. So the Commonwealth has filed a two-part motion, a motion for offer of proof regarding calling the elected sitting district attorney of Norfolk County and sequestration order if he is permitted to be called. This also includes Stephen Nelson, who is the victim witness person. So why don't I hear you, Mr. Lally or Ms. McLaughlin? I'll hear you on this motion.
Yes, Your Honor. So the reason for this motion is, as the court noted, they appear on the defendant's witness list. Neither of them, I believe, has received a summons in regard to it, so there's no motion to quash because there's no summons to quash. But with respect to each, as the case law is abundantly clear, in order for these witnesses from a prosecution team to be subject to being called as witnesses by the defense, the Commonwealth is just seeking some sort of proffer whatsoever as to what areas they can testify to and only they can testify to. So if it's information that the defendant can elicit either through direct testimony or cross-examination from, and I would submit whatever, I would believe that whatever testimony they seek from either of these witnesses, they could get ample testimony from a multitude of other witnesses. Specifically, the only point that was raised as sidebar during impalement was with reference to the district attorney testifying as to whatever issues purported issues of conflict or removal of Canton Police Department from the investigation. Certainly those are questions I think far more appropriate for members of both the Canton Police Department, members of the State Police CPAC Detective Unit. The head of that unit, Lieutenant Tully, is one of the Commonwealth's witnesses who will be testifying, and I think he's in a far better position to testify to that than Mr. Morrissey. But regardless of that, what the case law is very clear about is that, number one, the victim witness advocate is a part of the prosecution team, and in these sort of areas stands in sort of the same stead as a prosecutor himself. Secondly, with respect to whatever areas of examination are expected or anticipated from these two witnesses, there has to be some sort of proffer of what that anticipated testimony would be that they can't get from some other witness. Certainly, Mr. Nelson has been the victim witness advocate working on this case.
So why don't you explain to me, I did look at the victim's Bill of Rights, but why don't you explain to me exactly what a victim witness advocate does, the nature of the relationship with the victim's family. I know there was a lot of discussion about this in grand jury minutes that I read about scheduling appointments, meeting with people, things of that nature.
So, I mean, what to say assist, I think is doing it somewhat of a disservice as far as the prosecution. It's someone who works directly with the prosecutor on virtually every step of the case, as far as investigation, as far as pending motions, as far as trial.
Has Mr. Nelson been the advocate throughout the pendency of this case?
Yes, Your Honor. So for over 2 years, has been the point of contact with the family, has been with the family at each of the court dates, is assistant and very helpful as far as coordinating things with the family, coordinating meetings, scheduling meetings with witnesses, in preparation of grand jury, in preparation of trial, has communicated thoroughly with regard to issues of scheduling and all of those types of things.
Does he take calls like late at night from witnesses? Does he have a personal relationship with witnesses governed by a professional relationship? Is he somebody that they are able to call? There's been a lot of allegations of harassment of witnesses. Are those folks able to call him when something like that happens?
That is the person that they would call.
Okay.
Yes. So I think the bulk of the communications and conversations with witnesses who are not members of Mr. O'Keefe's family over the course of the last couple of years have been in relation to that issue specifically, as far as harassment, threats, intimidation, things of that nature, that he's dealt with admirably in relation to those witnesses.
Okay. All right. Who's arguing this for the defense?
I will, Your Honor, and I think it makes sense to separate out D.A. Morrissey and victim witness advocate Steve Nelson in
Okay.
this argument.
Let's start with Mr. Nelson.
Sure. Your Honor, the defense acknowledges that there are often times where, let's say, a victim witness advocate sits in on an interview with a witness or an alleged victim, but there are other witnesses in the room to whom or who could testify about the content of that, and that doesn't necessarily make it proper to call a victim witness advocate during a trial. I acknowledge that. I also acknowledge that the victim witness advocate has a job to do, and it puts them as sort of an intermediary between the prosecutors and the police and alleged victims.
So when you were a prosecutor, you worked very closely with victim witness advocates.
I did.
Okay.
Yes, and it's my experience being on the other side that informs my knowledge of that. But this is a different case with regard to one specific issue, and that is that we learned as a result of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert, but Brian Higgins talked about him specifically. Mr. Higgins was asked, where is his cell phone? Why does he not have it? Are you aware of the preservation order that was issued by Judge Krupp in the Karen Reed case? And the answer came back that he was given permission to destroy or dispose of his cell phone from victim witness advocate Steve Nelson.
Did he say destroy? I'm trying to remember the testimony. I don't think he said destroy.
I used the disjunctive rather than the conjunctive because from memory, I can't remember the precise language, but it was conveyed to. I'm told that the precise language was to get rid of, which would be consistent with what I had
told
said.
He could get rid of, not
Correct.
Told he must get rid of.
Correct. In other words, Steve Nelson is overruling a colleague of yours, your predecessor on this case, who issued a preservation order which was never lifted, and yet he stepped into the case, gave authorization that he did not have to give for the disposal of a phone, which is relevant.
Okay, is that the sole issue you want to?
Yes.
The sole issue.
Yes, that's with regard to Mr. Nelson. It's different with regard to Mr.
All right,
Morris.
what's the Commonwealth's response to that?
I don't believe any of that is accurate. So what counsel is referring to is there was a motion to preserve cell phones. The Commonwealth notified each of the witnesses that were subject to the motions and the orders, sent copies of the motions and the orders, as well as a letter explaining that. There were conversations in regard to that. There was then a subsequent Rule 17 motion filed specifically for the physical phones. There were conversations with those specific witnesses, just advising them that the Rule 17 motion had been filed. They had to, hold on to their phones, things of that nature, explaining what the process was. The hearing was conducted, the Rule 17 motion was denied, and then those witnesses were subsequently informed that the motion had been denied. I believe even from Mr. Higgins' testimony in the federal grand jury the counsel is referring to, he was specifically asked whether or not he had been ever advised by Mr. Nelson, myself, or anyone from our office that he could or should get rid of his phone, and he said no. So I don't know what further needs to be explored on that particular point, as the question was, all of these issues were explored in that particular area, and just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know is not true.
All right, so Ms. Giannetti?
We believe that that's a misstatement of what was testified to. I think it probably makes sense for this court to look at his very testimony so that you can make a decision on this, Your Honor.
So here's what I'm going to do. Let's wait and see. Let's wait and see how Mr. Higgins testifies. Okay? I am not going to order sequestration of Mr. Nelson, and let's see how the testimony is. And if you need to call him, you let me know, and we'll have another hearing on it.
Okay, we'll do. And just to answer an anticipated question from the court, I do not open on this issue.
You
either.
cannot open on that issue, Mr. Yannetti. Do you still need the 45 minutes?
That takes away nothing from my opening.
All right, so Jim, I'll start writing. I'll write something on this.
Your Honor, with regard to the sequestration, I think it would be appropriate for the court to order that Mr. Nelson and Mr. Higgins not discuss this issue from here forward.
Are you willing to have that happen, Mr. Lally?
That's fine, Your Honor.
Yeah, I'd order it, but he's willing to do it.
Thank
so.
you.
All right, so I just need a minute to write this up.
Sure.
All right, so regarding D.A. Morrissey.
Yes, thank you, Your Honor. So, Your Honor, the integrity of the investigation that was done in this case is certainly a live and important issue that is part of the defense in this case. I think the court would agree that we're entitled to question the integrity of the investigation, to attack it where we can. And it goes without saying that as the district attorney in Norfolk County, Michael Morrissey is in charge of that investigation. Now, in the usual case, that doesn't necessarily make a district attorney a witness. That would be unusual. There probably have been very few requests to have a district attorney testify in that regard. However, this case is different for two reasons. One is the conflict of interest regarding the Canton Police Department, which Mr. Morrissey was involved in. The second is the manner in which he injected himself into this case personally and made representations that we should be allowed to challenge.
Do you want to play that video?
We haven't made that decision yet. It may be that we elect to play portions of the video. It may be that we just elect to question D.A. Morrissey.
I have to think of other ways, right? That's part of the analysis that I have to follow in the law. So that's why I'm asking.
Of course. And I think before we get to that issue, Your Honor, the conflict issue is what puts him on the stand first. And we learned from the federal materials that former Chief Kenneth Berkowitz notified D.A. Morrissey at a very, very early juncture at 8:30 a.m., a phone call from Chief Berkowitz to D.A. Morrissey notified him that, Kevin Albert is on their force. He's the brother of the homeowner whose lawn contained the lifeless body of John O'Keefe, and that D.A. Morrissey was involved in that decision. He received the information from former Chief Berkowitz and concurred that the Canton police were conflicted out. And then the problem is that the Canton police they had their hands in this investigation, including that day after 8:30 a.m. and going forward. And there were, updates that were provided to Kevin Albert by a trooper under D.A. Morrissey's control, that, there were violations of that sort of conflict of interest taking Canton out of the case that D.A. Morrissey became aware of and that D.A. Morrissey did nothing about. And so in terms of, us being able to, attack, question the integrity of the investigation.
Why can't you do it through other witnesses?
We can, but the buck stops with District Attorney Michael Morrissey. He was the one that was involved at a very early juncture on this precise issue of the conflict, and he became aware that that conflict was violated time and time and time again, and he did nothing. And I believe that that's ripe for cross-examination. With regard to his statement to the press, this may even be more compelling, not because of the bias necessarily that he showed. That's not the strongest part. I think it is strong, but it's not the strongest part of his statement. His statement makes factual assertions, some of which we heard for the first time. In that videotape statement, he announced to everyone, including potential jurors, that Trooper Proctor never reported to the scene on January 29th. That's in direct conflict to police reports that we received from the troopers saying that they reported to the scene. And we would argue, trying to use semantics to get out of that, and now saying that for the first time in my career, I've heard that the crime scene is actually the police station that's across town. That doesn't make any sense. It doesn't pass the straight face test. But those are his own words, and he made himself a witness by uttering those words, and he also talked about his view of what witnesses did or didn't do and whether they're suspects or not suspects. Again, he injected himself into this case. He made himself a witness, and there's really nobody else we can question about his knowledge that he had when he made those statements and why he made those statements, and also the fact that, he was involved in this conflict decision from the beginning. So that's our offer of proof.
Mr. Lally?
I mean, as far as his statements, his opinions are completely irrelevant. And I think what counsel is referring to as proper for cross-examination, they might be. But this would be a witness that they're calling themselves. So for direct examination of your own witness, I think it's improper, number one. Number two, there is ample other avenues to explore this through other witnesses, which counsel can certainly do, as related to whatever.
As the law tells me I have to consider.
Correct. And so, as it pertains to whatever extent the court allows, as far as the Bowden defense is concerned, then I think it's fertile ground for cross-examination of other witnesses in respect to that. But as to whatever statements were made or not made by something that someone doesn't have recipient knowledge of, because I don't think anybody's saying that Mr. Morrissey was at 34 Fairview Road. So with all of those things in consideration, I don't think that it's even close to a valid proffer as to why the district attorney or Mr. Nelson need to testify on their own as to any of those things. The last thing I would just note is with respect to Mr. Nelson, the alleged mischaracterization that I made in regard to Mr. Higgins' testimony is actually contained on page 140 of his testimony.
140?
140.
Thank you. Could you read it? Do you have it there? If you don't have it there.
It's more so I don't know that I'm
Okay.
headed to.
Okay.
Your Honor, if I could just add one thing that I should have mentioned, which is on this issue of whether there's another witness that could testify.
Yes, because you did say, yes, we can get it in through other witnesses.
Yes, except the one thing we can't get in through other witnesses, potentially, is the phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only 2 people on that call, and the Commonwealth is seeking to take Chief Berkowitz off the witness stand as well.
Are you? I didn't see anything like that.
No, I'm not seeking to keep him off the witness stand. What I informed counsel is as to his current medical condition, and informed counsel that's why I didn't summons him. But I'm not seeking
I
to
knew nothing about this.
prohibit him from testifying.
My understanding was that the prosecution didn't believe that he would be able to testify.
This is the first time hearing any of that. All right. So it is a stretch. It is an uphill battle for you, Mr. Yannetti. I will allow you to revisit the ADA Morrissey at the close of the Commonwealth's case. Right now, that your offer of proof is not enough. I'll give you the opportunity to do it again based on the testimony that comes in, and I am not excusing him, or he is not subject to the sequestration order.
Understood, Your Honor. Thank you.
Okay. All right. So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards.
Great, thank you.
All right. So, when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday or the Friday before. I ended that with saying twice, is there anything else we need to discuss regarding housekeeping or logistics? And I was told no by both parties. And then I get a motion the following April 19th, the end of last week, about wanting to use not just having an a technology audio visual assistant at council table, but to use it's much more extensive than what I expected. The Commonwealth filed their motion and it was allowed previously because it happens in every single case in these courtrooms, and the Commonwealth shares their equipment. Please tell me exactly what it is you want to do, and I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Mr. Yannetti, talking to your client. So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So tell me, are there any agreements of counsel? Is there any... I know nothing about this, and I asked for information previously so I could have thought about it and, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said put it in writing. Then we put it in writing.
But the first time it was brought up was after I had asked about logistics. Go ahead. Tell me exactly what it is you want to do.
Okay. So it's a very modest request. Under ordinary circumstances, and we've utilized his services before, he would sit at counsel table and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court reporter, for opposing counsel. He can put monitors at the request of the court, put monitors on the bench, a monitor in front of the court reporter, a monitor in front of the Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of...
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean, we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for us if I'm up on a cross-examination or Mr. Yannetti is up on a cross-examination, and we say, okay, let's say we've got internal bait stamps that show photograph number 231. He'll know what photograph number 231 is. He'll have an outline that tracks our cross-examination or a direct examination.
So it will be only things that are in evidence or will be coming into evidence? You're not going to do that with disputed?
Absolutely not. We would never do that. If there's anything that's disputed or even remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. But no, all it is just a sort of a facile accommodation of seamlessly showing multimedia or playing an audio or playing a video for the jurors.
All right. What's the Commonwealth's position on this?
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever assisting with the trial. If that's what it's limited to, I don't know. About the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as equipment or screens or whatever is obviously fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. There are the jury seats. They're for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the judges. So the bottom line is, if we had known about this 2 months ago, we would have been able to really put the time into seeing exactly how this works. Ms. Tinetti, I'd like to finish first, and I'll give you the opportunity to speak to Mr. Jackson, to really see how this works, see how we set it up. I can't devote that time to it right now. No monitors, I don't want a monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that very small courtroom now at your request, so we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then the court can say, I don't want monitors that close to the jury. Then what I would do is just use paper copies. When I'm up on direct or cross-examination, I don't want to I can't prepare with the Commonwealth's.
No, I understand that. I don't think he'll fit at counsel table.
I can't speak to that. I think he would. I think we can accommodate him. Or if he doesn't fit right at counsel table, we've also set up, he was on a relatively large case that we had in a small courtroom back in California, and he's set up just behind counsel table, and he's got his own laptop, and nobody else can see it, and he's got a type of screen that you can't see it from angles, so jurors are not going to be seeing anything. But I need to be able to, and Ms. Little and Mr. Yannetti need to be able to prepare with him. And I think the court.
No, I understand that. I don't have a problem with that. It's the 4 monitors on the tables, one on the bench, one for the court. We're in a small room.
We won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's, again, a tiny room at your request.
He uses very modest speakers that are appropriate for the space. So, for instance, in this space, it would be probably a couple of speakers that are larger so that the jurors can hear, the court can hear. In a small space, he'll just pare it down and use small speakers. And there's a switch. So, for instance, he will work with Commonwealth's AV expert, and there's a switch on both tables. When it's my turn, switch, And now
All right, so
these-
is that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with. I mean, we just got Wi-Fi in this building a week ago. I mean, it's not a building that,
I understand.
we can just last minute. It's a beautiful old historic building. We want to keep it that way. So,
And we will not mess anything up. As a matter of fact, I was told that by the Commonwealth that she uses switches, consistently. That's not new technology. It's very simple. It just allows both of us to be able to prepare with the audio-visual portion of the case more seamlessly. That's all. We just want to make it more seamless and more professional for the court and for the jurors.
so it would be during your case in chief.
It would be during my cross-examination of every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
All right, with exhibits that are already into evidence, you're not trying to enter exhibits during cross-examination?
I mean, unless it's an impeachment that I didn't see coming. But even in that case, my habit and practice, my custom and practice would be to approach, if it's a matter in controversy, or tell the Commonwealth in advance, I'm about to show this photograph. Do you have any issue with it? No, I don't. And then we'll show it. But I would never, the point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be shown seamless and more professional looking.
Does the Commonwealth and Ms. Gilman have an opportunity to spend a little time today to take a look at it and see? I mean, everybody's preparing for trial, obviously. Again, this is, I don't have the time to do it, and I understand if you don't, but...
I think Ms. Hillman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told he was going to be here. So, but I'm happy to have Ms. Gilman.
Ms. Gilman, are you willing to spend some time today? Thank you.
By the way, just on Mr. Bates's defense, yes, he was supposed to come last Friday. He was told he couldn't come because he hadn't gotten permission from this court yet.
Okay.
We did not.
Well, that makes sense, frankly.
I just didn't want there to be a sort of a hanging chad where that's concerned. He didn't leave.
Well, especially where he didn't start out well, right? Being at council table during impanelment.
I understand that, and he's been told that was inappropriate and obviously would never happen again.
All right, so some sort of ground rules. Only one counsel, whoever's doing the cross-examination of the witness, objects. Just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission. At sidebar, there will only be one person talking again, and it'll follow with whoever does the examination. Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object. That's it. And if we need to see you at sidebar, we'll see you at sidebar. But I don't want a whole litany of reasons why the testimony you think is inadmissible. So those are pretty standard rules. I'd like to see counsel at sidebar regarding a jury issue.
Just a second.
We'll begin Monday morning at 10 o'clock. So we'll see everybody then.
Court, all rise, please.
Jim, there's one that I'm writing. You know what, Paul?